Blessed love my people, big up on yourself. Right now we have a video from Miss Kitty, and Miss Kitty has speak to a young female lawyer and Vybz Kartel and Sean Storm case. She said Kartel need medical assistance immediately. And she said, boy, if Kartel would have sued the state, you see me, after where him go through. So people, check out that video and big up on yourself. Bless.
The Court of First Instance, Court of Appeal, Privy Council, and then this time now the Court of Appeal again in front of the full panel, and of course freedom was granted on the 31st of July. And on the indictment would have been Sean Campbell, Adidja Palmer, Kaira Jones, and Andre St. John, correct?
Correct.
Very well. All right, Mr. Beat. So as the lone female attorney on this matter, what was it like for you, and what kind of work goes into representing a matter of this nature?
Well, I must say, to be the only female at this level was definitely an honor and a privilege. I work with some very great attorneys. We were young, quote unquote, as a collective in the profession, so it means a lot to us that the men were able to put their trust and their confidence in us to be able to represent them on this last leg of the matter, the team that was there. So it meant a lot. It's a lot for our careers, and it is a beacon, I hope, to young attorneys in the profession to never doubt yourself and never let anyone impose any limits on you and what you can do. I know that there is some that say that, you must wait your turn and you have to go through all these kind of processes and so on. But let me tell you, when you have great mentors and great guidance, it will make the work a lot easier. All you have to do is be receptive and to put in the work. So I must say, big up to Mr. Isaac Buchanan and big up to John Clark, who were great seniors to us as juniors in the matter. It really made a difference for us and the way that we were able to contribute to this matter.
Very well. Some persons, Mr. Beach, might wondering, but Mr. Beach, why would you take on a matter like this? It seems so heavy, it seems so big. The name Vybz Kartel looms very large. Why would you take a case of this nature?
Well, let me say, when we just came back from the Privy Council and I did that interview with TVJ, I won't lie, the people them did done me like buckle. Because they said, I'm defending a guilty man, and them did say the things and go on. But I knew what I knew about this matter, and I believe, listen to me, people only know Vybz Kartel and they know Sean Storm. I got to know Adidja Palmer. I got to know Sean Campbell. I got to know Kaira Jones. I got to know Andre St. John as persons beyond the fame and beyond whatever was going on in this matter. So spending time with them, what actually developed over time is their passion that they had naturally would have rubbed off on us. And so I can tell you, I can speak for myself certainly when I say this was a cause that I believed in greatly. It was so important to me because it's also important not just to the men, but to the development of our jurisprudence. It is so important to have our constitution be given such high regard, especially given that it was not treated so at the trial stage and at the initial Court of Appeal stage. It's important to see how now the court treats with our constitution, which is the highest source of law in our jurisdiction, in our country. It is the constitution above all else. So to see that, sadly, it took 13 years for them to have the constitution stand up for them and help them to be able to be free. But at least we are here, and that is why it's important to the development of our jurisprudence here.
Amen. All right, Mr. Beach, talk to us a little bit about what were the considerations. So talk to me about the points that you would have proffered, or your team would have proffered in terms of the appeal. What went wrong? What did you highlight to the court to say, court, these were the things that went wrong, and this is why the men did not get a fair trial, and this is why this sentence needs to be overturned, and they need not be retried, but they need to let go. What were those points that that you put forward?
Well, thankfully, in the press summary that the Court of Appeal has released, they beautifully highlighted a lot of the factors that we had put forward to the court for reasons why they should not be retried in the matter. For
Yes.
one, there is the inadequate account of the evidence that was used in the initial trial that would more than likely, and as the prosecution did say, would have been reused if there had been a retrial. There were some critical documents that were missing on the list
Yes.
of exhibits that was put forward to the court, and that
Mm-hmm.
would have been at a great disadvantage to our clients at the time. For one
Oh,
thing, the handwriting expert who would have seen the letter that was written by the sole eyewitness, Mr. Lamar Cho, he is now
yes.
deceased. So he couldn't have
Oh,
come
wow.
to the trial to have given testimony in relation to that.
Right. Hold
There
that thought
were
there, Mr. Beach. 1 second, please. Hold that thought. Good evening, guys. If you're just tuning in, thank you so much for being here. It's your Queen Diva, Miss Kitty, and we're talking to Alessandra LaBeach, the female attorney at law, who made part of the team of Isaac Buchanan, John Clark, and Mr. Chevrolet.
yes,
Chivalry. Right, that's it, right? Who were successful in putting forth the appeal to the Court of Appeal in getting Adija Palmer, Sean Campbell, Kaira Jones freed on July 31. Continue, Mr. B. So you said that some of the evidence was missing. The handwriting expert who would have testified in the court of first instance
right,
has died, so he
right.
could not be recalled. Yes, what else?
Right, and that's in relation to the letter that Mr. Chow had written to the public defender, I believe he's called, when he was
Yes.
saying that he wasn't given the evidence of his own free will and accord. That was
Oh,
something
I
that
see.
played a role at the initial trial. So we wouldn't have had him because there was some discrepancy as it relates to that. So that we believe if there was going to be a retrial, that would have been an important testimony to have included on the defense side. So
Okay,
that's
I
one of the
see.
things. And there
I
are
knew I
witnesses.
Go
Sorry,
ahead, go
go
ahead,
ahead.
Mr. Bish.
All I'm
No, I was
saying,
saying that the juror issue, the tainted juror issue, because when I watched the Privy Council, portion of it, the tainted juror, played a very important role, and that really was the seminal matter presented before the Privy Council, who agreed
correct.
with you that that in and of itself was problematic, and the judge in first instance should have aborted or disbanded the jury at that point in time, and he erred
Correct.
when he carried on with the trial. So talk to me about the other things that you guys put forth, please.
Right. So, in relation to that specific jury issue, it came up back again because we had concerns for how any pool of jury that would have been constituted for a retrial might have weighed those kind of considerations on their mind. And there was the risk in our mind of either
Mm-hmm.
overcompensating or undercompensating in relation to coming to a fair and reasonable verdict. In
Yes.
that there are persons who might believe, hey, remember saying we bribed the jury the first time, we gotta make sure they're guilty this time. That isn't the
Mm-hmm.
proper
Mm-hmm.
consideration because,
Mm-hmm.
according to the jury act, they must be guided by the evidence and their oath. They must be guided by the evidence that is put before them. They are not to
Right.
come to the fore with already a determination in their mind, but that would have been almost impossible at this time, having another issue. Most of the exhibits that were used at the trial are now out there in the public domain for everybody to
Yes.
see. That is problematic.
Yes.
So persons would have
Yes.
already formed a view, which is our issue. They would have already formed an opinion as to the innocence or guilt of the men before there was any trial, and that there was no guidance or direction that the court could give to have cured what
Mm-hmm.
we call and what case law has termed that poison.
Right, the poison, right. I saw the poison, right? And of course
Right.
that would have contaminated the entire jury pool, and that would have been a problem. And there were other problems, issues that I read in the Privy Council judgment, where they were saying also the time of the afternoon or evening that the judge gave the summation and told them to go and deliberate. They were like, listen, that was late, and they want to hurry up and go home, and so they did not
Right.
have enough time to properly consider the issues that
Right.
were presented to them. Yes.
Right, and then one of the major issues that even when the issues in relation to the jury arose, the judge himself did not make proper inquiries as to what was the state of the jury at that time. He relied on the information that was passed to him through the forewoman. And that we
Yes.
believe was a miscarriage of justice because they wouldn't, he, as the judge who was presiding, should have satisfied himself and not allowed someone who was not okay with the law to have been advising him as to what was happening. It was a serious issue, and we believe that just not enough was done. And the Privy Council has indicated that not enough was done at that point where the issue arose to make sure that the integrity of the jury was safe still for the trial to continue. He just took the word of the poor woman.
Very well, very well. So after the Privy Council overturned the sentence, they sent it back to Jamaica, and to
Mm-hmm.
have Jamaica make a decision as to whether he would be retried or would be freed. I remember
Right.
that there was an initial application made to the
Right.
court, and it was
Mm-hmm.
turned out. Tell us what that was about and why was that turned down?
So that application was an application for a habeas corpus.
Right,
As
bring the
far
body,
as
present
we
the body.
right, because as far as we understood it, they were no longer there in relation to any sentence. There was no charge. There was nothing against them that would warrant them still being in the custody of the state. Now that they
Right.
were basically, well, not physically free, but in terms of having legal proceedings against them, they shouldn't be incarcerated, is what we were saying.
Right, right, right. So that was a little damper when word came back that, for some, that he would not have been released at that time, but then he would have to be put before the full court now. So talk to us about what did you guys put before the full court, and what did the judges come back with on the 31st?
Right. So having dealt with that application, now we were before the full court. I must say that I am very grateful to our Court of Appeal for the way that they had managed this leg of the appeal. They were very time efficient. As soon
Yes.
as we got the order from the United Kingdom, from the Privy Council in relation to their sentences being quashed, the court was in correspondence with us, and they set the date for the hearing of the issue of the retrial. And also,
Yes.
after hearing the issue, after several days, they were able to come back to us with a verdict in very, very quick time. And so we
Yes.
appreciate them for that. Um, it was a lot. I have to one day take a photo of all the volume of documents that the court had to consider. We made sure,
Wow.
as their defense team, that every single thing that needed to be put before the court to make a determination in their favor was properly constituted and put before them in very organized fashion so that the courts would be able to do what they needed to do and peruse those documents with ease to have been able to grant us the favorable verdicts of an acquittal.
All right, hold that thought right there, Miss LaBeach, please. Attorney at law for Vybz Kartel, Alessandra LaBeach, right here on the live tonight, this evening, Kingston, Jamaica. We're not going to continue. We're not, so the numbers them are go up, because hello, this is very much exclusive, exclusive. And we definitely want to big up the queen, who was on the team, Miss LaBeach, for a job well done, along with her attorneys, fellow attorneys, Isaac Buchanan, John Clark and Mr. Chevry. So, they did the work and they got the desired result. And I'm quite sure that, many of you are breathing a sigh of relief. Many persons would have been waiting for 13 years now to get this outcome or to know what the outcome will be, because whilst, a matter is being appealed, it can go either way. And so, the uncertainty for a lot of people was like, oh my God, they were waiting with bated breath. Him now come out, 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 right? So tap up the screen, guys, spread the live, share the live. And of course, the heart me, guys, click the heart me. If you've not yet subscribed, please do, because that's what we do over here. We have exclusives, we have real people, what the real something that talk the real things them. And of course, this afternoon, or this evening rather, I have with me my colleague, my friend, my sister from another mother, Alessandra LaBeach, attorney at law for Vybz Kartel. So Miss LaBeach, talk to us now about the arguments that you would have put forward to the Court of Appeal as to why there should not be a retrial.
Right. So thankfully, my seniors were gracious enough to allow myself and Mr. Chevalier to also present before the Court of Appeal. And that was definitely something great for us as young attorneys. So big up to them
Right.
for entrusting us to do that and having the faith and confidence in us to be able to do that. So my main
Yes.
focus was the Constitution. I will forever say that the Constitution is the dawn of all dawns. It is the most
Yes.
important source of legal writing in our jurisdiction for sure. So what I'd urged on the court was to start with the Constitution. If it wasn't fair for them to have a retrial, and that would have been the end of it. It didn't matter how strong the prosecution's case was. It didn't matter the nature of the offense. If it wasn't fair, then that would have been the end of it. Of
Okay.
course, we
Sorry,
were.
sorry, Miss LaBeach. What part of the Constitution, on what part of the Constitution did you guys rely?
Well, we alleged several breaches. Most of the chapter we alleged had been breached. Their right to family life, their right to humane treatment, their right to their dignity, of course, their fair trial right, because given that the matter had spanned such a long time, it's almost 13 years, we had argued that the delay would have been a crucial point, and the Court of Appeal has agreed with us that the 13 years that has passed, almost 13 years since the commission of the offense, was a factor that
Yes.
was in favor of their acquittal.
Okay. All right. Yes. What else did you put forward to them?
Well, we did affidavits on behalf of each of the appellants to indicate, to basically give them a voice. All
Yes.
along, there are legal arguments and all kind of things that we could say as attorneys, but those affidavits allowed them an opportunity to speak to the court and to speak to the issue themselves. They were able to speak about their personal situations, individual situations as fathers, as sons, as uncles, as brothers, and what it meant for them to be incarcerated for 13 years and miss out on so much of their lives. They were able to speak about the expense that they would have incurred. They were able
Yes.
to speak to the delay and what it meant for them being in prison and waiting. They were able to speak to the constitutional breaches, such as the prison conditions, which are, boy,
Deplorable.
I saw a
Deplorable
video
to say
on
the least.
Instagram. I really and truly hope that that is not what the conditions in our prisons are. I know it was said at one point by the prosecution that it is not the Ritz Carlton, but I don't really believe that it ought to be the worst of the worst kind of condition,
Right.
because the fact of the matter is not only is our prisons filled with guilty persons, there are persons on there like our clients who are fighting for their right to be innocent in their matter. So
Right.
there are persons who are appealing and so on. And if it turns out in their favor, what do you do? What do you say to them, having had them condone to those kind of treatments and conditions for however long it takes for them to be vindicated? What do you say to them except that you're sorry? So I really hope
Right.
that this case will highlight the need for our prisons to have more humane conditions and come up to more international standards so that we will be able to be a little more proud of the state in which we keep persons. So that was
Yes.
one of the things that was highlighted as well. The psychological and medical conditions of all well, the psychological conditions of all four persons, and of course the medical condition of Mr. Palmer also
Right.
played a critical role. What would have been definitely evident was that we ensured that everything that we had to say was backed up by evidence. So we didn't just come and say, oh, they've been in there 13 years, they're suffering. We had the affidavits to prove it. We didn't just come and say, oh, Mr. Palmer is so sick. His doctor prepared a report and tendered it into evidence. So all
Right.
of those
And,
things
and that
help.
report and that report, Ms. LaBeach, is referring to his Graves' disease, the condition of his heart, because I heard Mr. Buchanan refer to the
Yes.
condition of his heart and the fact that it's not functioning at 100%, and he is gravely ill, has Graves' disease, and he needs medical attention urgently.
Yes, and the stress of the incarceration and the potential stress of a new trial was
Yes.
definitely too grave for especially him to have for undergone that kind of journey. Physically, it would have been
So
a crucial factor for him.
So you made your submissions, you were on your feet, you spoke to the judges, and you said, okay, if I may be of no further assistance to you, my lady, that is the end of my submission, right?
Yes,
Because that's how
yes,
we close, right?
right.
That's
And you
how we
adopt the
close.
submissions of those who went before you. Yes.
Very well, very well, very well. And when you finished and when you ended your submission and you would have sat down, did you have any idea or feeling or inclination that the result, that handed down by the judge would have gone, and the judges would have gone any other way? Did you feel like, yes, we definitely have it in the bag, or were you uncertain?
What I can say for sure is that we left everything there at the feet of those judges for them to be able to rule in our favor. It
Yes.
was, I don't, people wouldn't understand the amount of work and time and mental capacity that it took to be able to put that before the court. Listen, it's
Yes.
no small thing and a girl and boy thing. Trust me. For at least the 2 weeks before leading up to the hearing, God bless if I got like 4 hours of sleep. We were
Wow.
constantly engaging with the court. As the court says, hey, prepare this, we need that. We were on time, on point, making sure that we did not drop the ball at any point at all, and that those men got the best representation that we could possibly give to them. Listen, it
Uh,
was a lot. We had to make several visits to them, to the prison, to get them to sign stuff. And I must say, this is something that people don't know, but those
yes.
four men were very, 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 very involved in their case from
Yes.
jump.
How so?
We had to go in and speak to them. We had to let them know what was happening, what it is that we intended to do. We had basically, as we were doing the matter and reading the authorities, they were there reading the authorities too. We
Hold
had
on,
to
hold on. So
provide them with that.
Cartel, hold on. So Cartel, Sean Storm, Kyra Jones. I know Andre St. John is still incarcerated because he
No,
is facing
Tahira
another
Jones.
sorry, Kahira Jones, sorry,
Right.
is still incarcerated because he has another charge, right? That he's with which
Mm-hmm.
he's dealing.
Mm-hmm.
But you're saying that Cartel, Sean Storm, and everybody read through the
Okay.
authorities that you
They
gave them?
read they read cases. It's not just
Wow.
persons who you put documents before and they sign. They want to know why is this here. Maybe you can say that. And a lot of what is in their affidavits was what we took from them, and they made
Yes.
sure that, like, listen, this is important to me. I want to make sure that the court knows this. And that was so important, and I think it came over as very impactful. in the way that the affidavits
Yes.
were prepared. So it wasn't just, oh, a lawyer sitting at their office and they said, hey, this sound nice and this sound legal. Let me put this here. No, we took instructions
Yes.
from them, and they were very detailed, and they gave us instructions on what it is that they wanted. Listen, they were fighting for their lives. They were fighting for their freedoms. So when people say the
Yes.
judgment was a particular way, it is the hard work, dedication, and faith and trust in God that got us here.
Wow. So they were very integral and very
Very
invested
much
in their
so.
matter. It wasn't a situation like they were hands off and say, yo, I sat her, yo, Mr. Beach, just write anything, yeah, man. Yeah, just come
Nope.
and sign it.
Nope.
They played an integral role in their
Very
matter.
much so. And also
Wow.
their families were as well, because a lot of them had supporting affidavits from their families to bolster what
Yes.
we were saying, because especially in relation to the publicity point, they would be able to speak to it that much because they are in prison. But their families who
Right.
were out and seeing things and hearing things, that kind of information was also before the court, especially
Yes.
as it relates to the publicity issue.
Okay, all right, very well. So D-Day came and the judges are there. You're in the courthouse now, awaiting the handing down of the judgment. Bring us back to that day. What happened? How were you feeling? And what did the judges say in their handing down? Because I gather that I have perused the document, the judgment, but there were like 12 points that they listed, right,
Right.
as to what they took into consideration to arrive at this verdict, so to speak. But take us
Mhm.
to that day in the court. How were you feeling? And what did the judges say?
Well, I won't lie, because we were very anxious, so we just wanted to hear this in a retry them or did not retry them.
Yeah.
But a lot of prayer went into, especially the day, since the day that we got the date of the judgment. A lot of prayer.
Right.
And listen, I must I bigger up today on Mr. Campbell's post, but let me just say big up to Miss Cherry. That is Sean Campbell's mother. Listen, that
Oh,
woman is a praying woman, and when I speak to her on the phone and I hear her bless us and pray for us and cover us and protect us, listen, it is those kind of things that led to this. All the positive energy from the Gaza nation. Everybody was just praying and support. Of course, there's going to be the naysayers and the people who have this and that and a third to say, but we tapped into all of that positive energy, and all the persons who
yes.
adopted our mantra of God and time, and we held on to it and we believed in it
Yes.
firmly. This appeal, this part of the appeal, especially, I can tell you, I believed in wholeheartedly that it would never have been in the interest of justice for those men to have been retried. The factors
Right.
just would not have allowed for it. So to hear the Court of Appeal adopt our submissions, and some of them are put into the 12 points that you have highlighted earlier, it was just beautiful to hear
Yes.
and to see that the hard work and the faith that we had in this matter would have turned out so beautifully. I saw a photo that Mr. Palmer posted of himself with his fiancée and his daughter, and it was just so beautiful to me, because we know we've spoken to them. We have, I don't know anyone who would have had a better appreciation of what that meant to them except for them themselves. And then I see
Yes.
Mr. Campbell with Miss Cherry playing the piano,
Yes,
and
the
it is
piano.
just
Yes, I saw
another
that today.
beautiful. If you listen to that woman talk about her love for her son, it is something beautiful. And then you would
Unconditional.
have, trust me, nothing like a
Hmm.
mother's love. And then you would
Hmm.
hear Mr. Palmer's children talking about how they've missed their father, how they have
Yes.
suffered because they have not been able to really grow with him, and he was a loving father to them. So persons
Hmm.
don't see them as the loving fathers, and how Mr.
Hmm.
Campbell would
We
have
see
been
them as the
taking care of his
artists.
needs.
We see them,
Right.
yeah, we see them as the artists, but then they have a family. They have people who love and depend on them and who know a
Right.
different side. Yeah.
Right, and
Yeah.
people whose lives were forever changed from the 30th of September for some and into October for others when they were first taken into custody. Remember that from the moment that they came and put cuffs on them, they have not been outside of prison again. They
So
didn't have
tell me now,
the
Mr. Beach.
opportunity to have bail.
Yes, yes. Tell me verbatim now. What did the judge say as she was highlighting? And when did you figure out? Yeah, man. Okay. Yeah, we got it. What did she say? And what were the points in the judgment that she highlighted?
All right, so of course she would have indicated that based on the allegations, the nature and seriousness of the offense really one that was egregious and that was beyond argument. They had a
Yes.
thing where they were saying what the allegations were. No one can argue with that. They said it rightly in the press summary that it was egregious in nature. Um, and that that murder is prevalent in our country. So that is
Right.
another factor that would have weighed in favor of them having been retried
Yes.
for that issue to be settled. However, after making that point, she went on to speak about all the other points. What is missing from the press summary, but they did indicate that we must not hold hard and fast to what is in the press summary because there will be a written judgment that will
Right.
speak more in depth and be more authoritative as to what the decision of the court is. The publicity issue did not, in the mind of the court, play as integral a role as we would have hoped in them coming to that decision of the acquittal, what they termed as pre-trial publicity. However, I believe we would have wanted it to be another consideration, not just pre-trial in terms of leading up to the initial trial, but all of it from the initial trial all the way up to if there had been a retrial, which is
Yes.
there's a case called Putman. This is the Putman point that the poison there was no way
Yes.
of reining that back
Curing
in
that
or
ill.
saving
Yes.
right. So that was really the publicity issue from our side. We'll see how they treat with that in the written
Yes.
judgment. But the fact is
It's
that
almost
they believe
that case is almost saying that the poison is so inimical to the process. It's like you can't go around it.
right, right. So
Yeah, you
there's
can't go
no
around it.
direction that can be given, nothing that could be used to allow persons to be impartial and unbiased when sitting on
Yeah.
that panel of jury to make the decision. Of course, it
Yes.
is weighed against the point that you always have celebrity persons before the court. That cannot be something that the court says, oh, because this person is famous, we cannot try him and we cannot find persons who will be able to be unbiased and impartial. But we believe that
Yes.
because of the history of this case and the leaked exhibits, those were the things that would have added to the poison and would have caused them to not be able to be tried by an independent and impartial jury.
Jury. Okay. And then she said the words that you wanted to hear. Which were?
But there were other, of course, it is an acquittal. To God be the glory. God is the
Yes.
greatest. God and shine.
Yes.
But the other point that she raised was the inadequate accounts from the prosecution as to the availability of witnesses. So they had no affidavit evidence, whereas we tried to make sure that everything we did was backed by evidence. All
Right.
they had was, well, they did have affidavits from other Crown Counsel indicating that these list of persons are available, but not from the witnesses themselves to say, I've been contacted by the prosecution, I am still alive, and I'm willing and able to give
Come
evidence
forward.
again. Right. So that was absent in this case. Um,
Okay.
as we indicated before, witnesses and trial exhibits were unaccounted for, and persons who would have played a part or who would want to play a part would not be available for a retrial. Of course, of note is that this is one of the most complex and the longest trials that took place in our jurisdiction. It lasted for 64 days initially.
Right.
And we
Right.
had indicated to the court that if it is that the matter was to go forward to a trial, we would have been objecting to some of the evidence that was used at the initial trial being exhibited again for the retrial.
Right.
Everyone
Right.
would know by now that there were objections to some of those evidence being tendered at the original trial. We indicate that we would maintain and further object to those things going back again. The cell phone evidence is one. There is technological reports that say that there were issues with the way that the information was collected and even the information itself that was found on the devices. There has been proof now from experts that there was tampering and there were difficulties in how those exhibits were tendered in the first instance. So that would have been a consideration if they were going to have a retrial. You would have to account for the time that it would take to resolve those issues as well.
Yes.
The court spoke to their resources. We know that our courts are strained. There are a lot of matters that are pending, even without this being a matter for them. So if it is that we're to
Listed,
say,
yes.
okay, let's say a hallmark it for another 64 days, that's at least 3 months of the court resources and time, which means that
Yeah.
persons who are waiting for a trial, they would have to have their
Be
matters
bumped
pushed
down.
back.
Pushed
Right,
back, yes.
because a
And that
retrial
is
would
why
have been
sometimes
given.
and that's why sometimes, like say, when to sue somebody, you have to think about this thing, because court dates now we're getting like 2025, 2026 dates, you know what I mean?
Right.
Because there is so much there are so many matters in the system, it don't even make sense sometimes, really, you understand? That's why some people even here on the internet, them chat off them face and them do all kind of thing, but then when you think about it, you say then you never have no fixed address for me really even find you, you know, have no it makes absolutely no sense, you know what I mean? Yeah.
Had breached the men's constitutional rights. And
they did.
they did. So that is undisputed, and they did not go on to apply the Oaks test to say that it was demonstrably justified in a
Justifiable in a
free and democratic society.
free and democratic
Right?
society.
They didn't
Yes.
speak about any least restrictive measures. They didn't do any of that kind of justification. So on their own admission, and as the court has indicated, it is the unjustifiable interference with the appellant's constitutional right to a fair hearing. The other issue was the potential prejudice that at least 2 of the appellants would have faced. That would have been Mr. Jones and Mr. St. John, I believe, in relation to the period in which they would have been able to be eligible for parole.
Right.
What the court indicated is that if they were convicted after a new trial, they would be required to serve a longer term of imprisonment before they would have been eligible for parole. Some of them would have actually served their parole time if it went to a retrial. By the time it was retrial, they would have served the entire parole time.
So they would have to start over, which is inhumane and unjustifiable.
Right.
Yes.
Right. So those things are given consideration. We're giving consideration, and what the court at the end said that having weighed all the relevant considerations in the balance, because it is a balancing exercise. Once it is that you're going to have a retrial, there are a lot of factors, and it is the weighing of those factors that will determine whether or not there's going to be a retrial. And they said that the court concludes the interest of justice do not require that a new trial be ordered for the appellants, and the court therefore orders that judgments and verdicts of acquittal are entered in relation to the appellants, and there began the joy unspeakable.
Wow. I guess they heard wherever they were in their cells what the verdict was and what the outcome was. I can only imagine the jubilation that they must have felt. But one of the questions, so they're out, everybody saw it all unfold on TikTok, on social media, and in traditional media as well. And of course, the fans, family members were quite jubilant about what would have transpired. But at this juncture, persons are asking whether he is going to sue or the gentlemen are going to sue for my brain. Yeah, for malicious prosecution and or false imprisonment. And so I wanted to. We are creatures of instructions as attorneys, so it
Right.
depends on what the clients want to do, and it depends on what the client instructs us to do. But from
Right.
where you sit, would that be plausible? Would that make sense to sue for malicious prosecution and false imprisonment?
Well, as it relates to malicious prosecution, what they would have had to satisfy was that there was a criminal offense, they would have been acquitted of the charge, or it was determined in their favor, and that the prosecution set the law in motion without reasonable and probable cause. I believe, and the last thing is that in so setting the law in motion, the prosecutor was activated by malice.
Malice,
Um,
yes.
right. So the hardest part, I believe, of this would have been that the prosecution was set in motion without reasonable and probable cause.
Exactly,
Now,
because with
there's
all
a
the
lot.
evidence, with all the
Right.
forensic evidence, with all the witnesses, it's going to be a very
Right.
difficult task.
Hurdle, right.
The hurdle to
So
prove
I'm not
malice, yeah.
giving any pronouncement on it. Internet, do not come for me. Like on the come for me before, please. Please, I am begging. I wave the right flag. Um, I'm not making any pronouncement, but that would have been the greatest hurdle if it is that they were doing that. And I can tell you right now, they're more concerned with reintegrating into society and spending time with the people who they love, who they've not gotten a chance to see in 13 years. They would have
Yes.
seen us. They must say that was tired of doing overcome the and collect instructions and do affidavits. But they are now with the people who they love, who miss them the most and who most suffered from their absence, from being able to see them, touch them, and hold them. And that's why I tell you, those moments that are captured now, they are so beautiful to
Priceless.
see. Trust me.
Yes.
Even now, it's
Yes.
like, we really did it. They're really free.
Yes.
So I can just imagine. Because first of all, I know they, they're just now going to know what it's like to skate on the toll. There was no
Yeah.
toll like that when they
Yes.
went into prison. Come on now.
Yes.
Even just the
Yes.
journey, I can imagine from the prison to their homes must have been
Yes.
like, listen, the place was
Wow. All of this happened
even
while
the
we were away.
waterfront,
Yeah.
right? Even the waterfront is
Yeah.
developed. Like I remember the first time I saw it, and I'm out here, in these streets. The
Yes.
first time I saw it, I was like, okay, this just a different. It's like I was driving a different place, just a little painting and like
Yes.
a project that we did done by the waterfront. You can just imagine them now leaving prison
Yes.
and
Taking it
making
all
that journey
in.
home. Listen,
Yes.
I was joking the
Yeah.
other day with Mr. Buchanan. I'm like, listen, you see them supposed to go Ocean now, you go this, them go Flatbridge and go around
Yes.
Morganton. They don't know the difference
Yes.
at all. And that's
So
just the
yes.
reality of persons being away from society for so long. It's going to take an
Yes.
adjustment. I
Yes.
go visit my mom, and there are persons who have put up houses and so on in the little time. Like probably I take like 2 to 3 weeks between visiting my mom. And every time
Yes.
I go there, there's a new thing directed, and it just changes the whole area and ambience of making that journey. So I can just imagine what 13 years has done for these men.
Yeah.
So I'm just happy that they're
Wow.
taking the time to kind of soak it in and to really spend time with the people that they love. Nothing, I think, can beat that for them.
Yes. And
Because
I
you
think
hear them
especially
talk
for
about
Mr.
their
Palmer as
love.
well. For Mr. Palmer as well, obviously his health situation needs
Exactly.
urgent attention, right? And before,
Hmm.
I know a lot of persons are very excited and, waiting with bated breath for the announcement of when the party will keep and the concert will keep. But I think what is the matter at hand that is most important is his health.
Is it
Because if
health?
he's not
Right.
healthy and strong, then he can't perform if that is what he so chooses
Right.
to do. So,
And I
that
want people
is,
to understand it is no joke thing. He really, really and truly is very, very ill. And he is, as far as I'm aware, making every effort to ensure that he's in the best of health, given that he's had the opportunity of his freedom. We made sure that we did what we needed to do to ensure that he was taken care of when he was in there. But I'm happy, elated that he is now able to go and get the help that he needs to fully and better recover. Trust me, that is phenomenal, and I'm grateful that the Privy Council was able to take it as a serious matter, which would have expedited the hearing date for the Privy Council leg of it. We did an application for that to be facilitated, and they were mindful of that when in the way that they were able to facilitate the hearing and the delivery of the
Yes.
judgment. So I'm grateful for that, and I'm happy that our Court of Appeal as well took steps to ensure that they did not languish with the matter and that we got a judgment in record time. So I'm really, 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 really happy. So I hope that people don't think it is a stunt. It was not a stunt. It is not a ploy. It is not a phantom thing. It is very real that he is ill and he's trying to ensure that he gets the care and attention he needs. Of course, when the time comes, he will speak for himself and say what is going on. But I think it is important because I've seen it out there. People are saying, "Oh, probably we just did it to get the judgment in his favor." And people say all kind of things, but don't joke about people's health and their
Health,
safety.
yeah.
They did the same
Yeah.
thing for the gentleman who played the Black Panther until they found out that he had cancer. Don't
Yes,
joke
yes.
about
Chadwick
people's
Boseman.
health.
Mm-hmm.
And remember,
Yes.
the same knife will stick sheep, will stick goats. So don't end up in a position where you're making fun of someone and their sickness and their state, and then you see the same thing happen to you. God don't like ugly.
Definitely not. And well, Lexi, I gotta tell you, I'm so very proud of you, so happy for you. We know how even before we became lawyers, we know how difficult the road is to get to. And by the way, when you're an attorney unless you get disbarred, like you do something from the bar, right? Struck off. So I'm an attorney at law. Alessandra Beach is an attorney at law, and yes, we're both attorneys.